Hello, hello. Good afternoon. It's Tuesday at 4 o'clock. It's time for another teissTalk. Apologies, by the way, if you were expecting Jenny Radcliffe, my co-host for today's teissTalk. I've stepped in for Jenny, so apologies if that's a disappointment for you, but I'll do my best to step into her shoes or her high heels. I'm not quite sure. Never seen Jenny's feet because we've never actually met in person. I've only ever seen her sort of, torso upwards. So anyway, there we go. But yes, welcome to another teissTalk. We are live every Tuesday at 4 p.m. and in a change to the scheduling, we're also going to be live Thursday at 4 p.m. It used to be 10 o'clock in the morning Thursday. It's now going to be 4 p.m. both days. So Tuesday and Thursday, both at 4 p.m. Somebody's asked me to try and do Jenny Radcliffe's accents. That's not going to happen. The other thing that's not going to happen today is any football talk. I know there's a match on later today. I don't follow it. I have no idea what's happening. I understand the context. I understand we're playing Germany. So if you want to do football banter, fine. Just don't expect me to interact with any of it whatsoever. We have more important things on our minds to be discussing today. We have got a fantastic panel to talk to us about international transfers of data, moving your stuff from one jurisdiction to another. And we're going to concentrate on the InfoSec side of this. And usefully enough, we've had a decision recently from the EU, between the EU and the UK, on adequacy of transfers of data, which we'll be discussing with our panelists. And also, that leads me to our teissTalk mug. We give away a teissTalk mug if anybody wants to win one. Today's contest to win a mug, I was thinking of the radio news quiz where they ask people to come up with entries. So I'm going to ask you, given that we've had an adequacy decision from the EU, and we're very excited about adequacy, which seems very strange to me, we're adequate, woohoo, fantastic. But if you can come up with a movie title that you can ruin by including the word adequate. So take a movie title, substitute the word adequate, and ruin the movie title for me. The best movie title that's been ruined by the word adequate wins a teissTalk mug. Hope that makes sense. Anyway, stick it in the chat tab. Also, if you've got questions for our panelists, there's a Q&A tab there as well, so do stick in questions. So let's introduce our panelists. We're going to be hearing later on from Rebecca Rakowski, who's managing partner at Expan Law Partners, and also Bosko Wojcic, who's Group Data Protection Officer and Head of Data Protection at Ergomed PLC. So they are going to be joining us later on to talk about this, some really interesting perspectives on the data protection. Martin Hoskins has submitted mission adequate. I like that. That's the stuff. Keep going. But our main guest, our lead guest, our first guest on this certainly is Fred H. Cate, who I'm delighted to introduce, Distinguished Professor and C. Ben Dutton Professor of Law at Indiana University. Welcome, Fred. How are you doing today?
Thank you. I'm great. And I think my submission is, instead of Top Gun, Adequate Gun.
Adequate Gun. It just gives and gives, this gag. I really like it. Yeah. And you've been with Indiana University for many, many years. I mean, just before we get started, can I ask you what keeps you there? You haven't been tempted to move to another institution?
There have been lots of opportunities, but it's a great place to live. And I spend a lot of time on the road, a lot of time in the UK, but it's a great place to come home to. And I work with colleagues in computer science and law and business, and it's a terrific combination of folks when you're working on these interesting data security and data privacy issues.
Yeah, that's interesting. I wanted to ask about your interface with the computer science people, because obviously I think now that would be considered standard. But how long has that been going on, and was that a difficult balance to when you went over to the computer science faculty? Did they look at you as a visitor from another planet?
You bet they did, and they still find it kind of hard to believe that a lawyer, a solicitor, could have anything useful to contribute in the world of data protection and data security. But it's actually something you see around the world. A lot of CISOs now are actually trained as lawyers, and even some CIOs trained as lawyers, because a lot of this isn't about technology. It's about managing risk and about understanding the different types of risk we face, which unfortunately aren't just technological.
Yeah, of course. Yeah. And that's the thing. I mean, that's why I find the data picture really interesting, is it straddles those two different worlds of law and compliance and practice and, data security. And I tend to find when we have these discussions, we sort of end up talking about the one and the other. I don't know about you, I find it quite difficult to not end up on one side of the fence and to keep the conversation in the middle and keep both hats on, as it were. Do you find that?
Yeah, I think it's right. And, there's always been a kind of uneasy but almost integral tension between privacy and security. I mean, you can't have good privacy without good security. But on the other hand, security and privacy are also, they're often in tension. And a lot of folks know from a budget side, if you're in a company, if you talk about privacy, it's still pretty hard to get money out of the folks upstairs. But if you talk about security, it's usually a lot easier to get people to pay attention if you talk about a security risk.
Yeah, interesting. Yeah, particularly with boards, it's speaking that security risk language, isn't it, and trying to sort of communicate in those terms. By the way, I've just been distracted. Bill and Ted's Adequate Adventure is one of my favourite entries so far. I do quite like that. The Adequate 7, also another one. Also, Fred, I want to talk to you first of all about cultural differences between the UK and the US, because just as an investigative journalist, the amount of data I can find out about US citizens immediately on the internet compared with what I can get about UK is unbelievable. I mean, a few dollars and I've got somebody's cell phone number in the US that I'm trying to track down. I can't think of that happening in the UK legitimately. Do you feel that atmosphere is changing? Do you think the US is getting more privacy focused?
It's a great question. It's a funny one to answer though, because, everybody says they worry about privacy. I'm going to call it privacy if that's okay. And everyone in the UK, everyone in the US, 98% of people say they worry about it. But when you look at their actual behavior, people in the US are typically very different about it. And they're willing to trade privacy for anything they perceive as a benefit. And also, people really don't like being slowed down when they're trying to do something. Like, nothing's more irritating than when I call a theater in London to make a reservation and I get the privacy notice being played to me over the phone. And I'm like, how do I opt out of listening to this stupid notice? I just want to buy a ticket. I don't care what you do with the data. Now, to be honest, I'm not sure that it's that different from one culture to the next. I think it's largely the way in which our laws have reflected that is very different.
And also in the US, you've got this, obviously a federal system. And so there's that extra layer of complication on top of it. Just for the folks like me who are on this side of the pond, are there overarching privacy laws in the US, or is it all done on a state-by-state basis?
So there are lots of federal overarching laws, but they are all sectoral. So they apply to, we have a financial privacy law, we have a health privacy law, we have a video rental privacy law, we have a telephone privacy law. What we don't really have is an overarching broad, GDPR or European-wide law, or even like the UK has now with its national laws.
Yeah. And to what extent then can companies in the US do what you might call privacy law shopping, where they can go to different administrations, different states, and pick the one that has the regime that gives them the most favorable edge in terms of this?
It doesn't work as well as actually it does in Europe. So in Europe, I might pick where I want to be headquartered for privacy purposes because I think the data protection commissioner in that country is going to give me a better deal. In the US, you've got to comply with the state law in every state in which you do business. In other words, we don't make any effort to harmonize those state laws. So you can live in Indiana, but if you've got customers in California, you've got to comply with that California law, even though it's much more restrictive.
Right, interesting. Yeah, that's an interesting aspect to it. So, we just sort of steered into this territory anyway. I think we should probably talk about the recent moves in the UK and between the UK and the EU. We've obviously had, for those who haven't caught up on this in the last couple of days, a decision by the EU that they have deemed the UK data protection regime adequate, which we're all very excited about and happy about the adequacy of that. I'm still getting some fantastic entries for our film choice. I might leave it to the Tice elf, to our Tice assistant, to pick a favourite one. But yeah, so this was to a certain extent expected, but there were a few wrinkles along the way, weren't there? There was this issue about the UK suggesting that we might go our own way, go rogue at one stage.
So it's useful maybe just taking one step back. So the European Union has a broad European-wide data protection regime, and that regime says you can move data freely within all the countries who are part of that, 27 countries, no restrictions on that at all. But if you go outside of the European Union, then you have to have a legal basis for doing so. And one of those is adequacy. So your laws have been reviewed by the European Union and found to be adequate. So the UK, of course, was part of the club, and then when it left the club, the question was, would it be found to be adequate? And it did get the adequate decision last week, widely expected and richly deserved. I don't think there's any question. But, there was a little bit of hesitancy about this. So one thing is this is the first of all of the more than 24 adequacy decisions that has a time limit. It expires in 4 years, and it will have to be reviewed every 4 years. So unlike other countries with adequacy, which got it forever, the UK is going to have to reapply every 4 years and submit to union oversight. And that's a bit of a blow because, 4 years passes really fast in this world.
Yeah. And presumably, yes, if you're planning 4 years ahead, for example, if you're acquiring any kit, if you're, reviewing a security vendor, maybe you're particularly as the sands of time run out, you get to the end of that 4 years, you're thinking, hang on, before I make this purchasing decision or before I make that deal, I should just wait and see what's going to happen over the line, as it were, over the window.
Exactly. And I mean, part of the problem is what happens if you're not adequate, because then you fall back to these kind of really suboptimal approaches. I mean, one has been called standard contractual clauses, where you lock up all your data using clauses that are in contracts that have been approved by European regulators. But that's a kind of lawyer's nightmare, because all those clauses have to be signed by like every part of the company. You're a big multinational company. You've all got to sign on to it. And then that has to follow the data wherever it goes. So if you pass it on to another person or you go to another country with it, the standard contractual clauses have to follow. So it's a pretty bureaucratic approach if you're not in the club. So you're an EU country or you're adequate, or you've got to do it in this very transactional way that applies to the US and Canada and other folks. And Canada has been found adequate. Now that's being questioned, but Canada is part of the club right now. So
yeah, interesting. Scott Wilson's made a good point, actually. He says if the UK wasn't considered adequate just 6 months after being a member of the EU, then who exactly is? So it's, yes, as you say, hardly a surprise we'd get the seal of approval now. But of course, as we, the culture sector in the UK has talked about, Britain being having the opportunity now to kind of exploit our data environment. Is there a sense of how far we'd have to move away from the EU before they say, hang on, we're not going to renew in 4 years? What are do you think there are hot button areas that they're going to be looking at?
They're absolutely hot button areas. And one that they identified in the adequacy decision was immigration related information. Another, which already back when the UK was in the club, part of the European Court of Justice already was looking at the UK, Belgium, and France, and found that their national security activities threatened their ability to offer appropriate privacy protection. And so you can imagine 4 years from now, I don't expect the UK to stop any of its national security activities. And that 4 years from now, that could be, and of course, that's exactly what got the US kicked out of the ability to share data, was the Court of Justice ruled just last summer, July a year ago, that because of national security surveillance in the US, European Union nationals' data could not be sent to the US any longer under the agreement then in place, given the sort of sad name Privacy Shield, or under now even standard contractual clauses have been called into question.
Is that so? I thought the fallback was standard contractual clauses for getting stuff to the US. You're saying that's not?
There's no real fallback here. In other words, they overruled Privacy Shield, so it's gone. And then they said that regulators had to re-examine standard contractual clauses, because you see the problem. In other words, if a company, if you've got a supplier in the US and you're sharing data with them, if the government comes asking for their data, they can't say no. There's nothing you can contractually do about it. And so this is a little bit of, the emperor has no clothes. Like, we're all pretending. And in fact, the European data protection regulators issued a statement, an opinion in June, so earlier this month, saying, oh, well, here are all the things you can do. You can check, you can verify, you can make sure. But none of that makes any difference. If the FBI shows up with a warrant and says, I want your data, they get your data. But by the way, the same thing's true in the UK and virtually every other country in the industrialized world.
Right, interesting. Robert Sparks has asked a good question, actually. He says, is there a cost of moving from adequate arrangements to standard contractual terms, given how much red tape would be involved? So, I mean, I know I've read standard contractual terms are costly. I guess Robert's question is how costly and why?
Wildly costly. So you have to, again, it's great for lawyers. My students really benefit from this. But you have to go through, look at all of the data you're moving. You have to put contracts around all of it. You have to get the contracts approved by European regulators. And then you have to make sure that the contracts follow the data wherever they go. So, it's a little bit like trying to, catch flies in the air. Data has a tendency to move pretty freely, even when we don't want it to. This is why it's so hard to secure. And so making sure that you have a contract in place that follows that data element everywhere it goes. Every supplier, if somebody prints your envelopes, the contracts have to flow there. Very burdensome, very expensive.
Well, so I'm glad you introduced the US example in this, because obviously there's now the issue that the UK is now outside of the EU. So even though the EU has said that the US regime isn't good enough, it's open, isn't it, for the UK to say, well, we think it's okay, given the closeness of UK and US intelligence agencies, it strikes me as feasible that could happen.
Yep, I think that's entirely likely, and in fact, it's one of the things that could help. London's long been a center where many, many U.S. businesses wanted to be headquartered in Europe. Then, of course, when the U.K. was no longer part of the EU, that raised the question: would U.S. companies want to go someplace else? This might now be a kind of island, a stepping point on the way to Europe to say we get from the U.S. to the U.K. and then we use adequacy to get from the U.K. to Europe. I think European regulators, though, are going to watch that like a hawk. Again, I think that's another reason we see that 4-year review period to say, look, all bets are off at the end of 4 years.
Yeah. Really interesting. Yeah, because that again sounds like jurisdiction shopping, doesn't it? That you're playing off jurisdictions one against the other. I'm going to introduce our other panelists. There's lots of questions I've got, and also I'm aware our attendees are coming out with some lovely film titles. Too many for me to keep an eye on. I'm trying to concentrate on what Fred's saying. But there were some great ones. Spider-Man: Far From Adequate is my favourite so far. From Lee Morton. I'm going to introduce our other panelists to have a chat with us about this as well, and to pick up on all of this. We have Rebecca Wachowski, who's managing partner at Expan Law Partners, and Bosko Wojcic, who's Group Data Protection Officer and Head of Data Protection at Ergomed. Hello to both of you. Bosko, can I start with you first of all? For people who haven't heard of Ergomed, what does the company do? What's your industry?
Sure. So we do a lot of different things, and we are in the pharma industry for more or approximately 25 years already, and we have three main divisions or dimensions of our business. So the first one would be full CRO, it's clinical research organization. So we provide support and assistance to various different sponsors that would be pharmaceutical companies or biotechs. But then as well, that's not the only thing that we deal with. We also engage in a lot of different clinical trials around rare disease. And it is really very specific type of clinical trials, because up there, you really need to have a patient-centric approach, and it is very, very, very tricky. So that's the second one. And then the third one, probably even the biggest one, is the pharmacovigilance sector. And we are providing various different types of pharmacovigilance services, starting from case processing, clinical safety, post-marketing, but then as well medical information, literature screening, etc., etc. So obviously, to sum up, we process a lot of personal data, and not just the regular personal data, but actually very sensitive personal data, and that's the health data.
Nice, yeah. It's interesting. I mean, obvious question is, in terms of coronavirus, what are you involved with any of the sort of major vaccines, the AstraZenecas, the Pfizers, and so on?
No. Around vaccines, no, but we were very, very happy and proud, actually, that we supported a couple of different clinical trials in Italy, especially in Bergamo and Bergamo Hospital, when it was really a very, very terrible situation over there. So we performed a couple of different clinical trials supporting some of the pharmaceutical companies that already have their products on the market, but there was a chance to actually use those kind of products to help the really severe health conditions of the affected.
Yeah. I think we all remember seeing those scenes from Italy, and it was pretty harrowing. Thank you, Bosko, for that. It's good overview. Rebecca, you're advising on these kind of matters. Is there a particular type of industries that you apply to, do you advise or give advice to or consult with?
My firm is a data privacy and cybersecurity law firm, so that's all we do. But we work in almost every vertical. But as Fred mentioned, in the United States, a lot of the privacy laws are segmented into industries. So we do a lot of work in the healthcare and financial vertical, but I found that also manufacturing and things like that, because you have supply chain issues there and suppliers are located internationally. And so you may have things like GDPR becoming something that's, and the data transfers associated with that will, trigger, standard contractual clauses or things like that we need to discuss, and different contractual provisions around that. So,
yeah. Well, it's interesting. So staying with you, Rebecca, I mean, Fred's outlined this slightly troubling position where not only is Privacy Shield in trouble, but standard contractual clauses might be affected as well. How are you advising your clients on that? What's been the reaction?
Well, so I've been dealing with it obviously from the state side. So a lot of my clients are, need to continue to transfer data across the Atlantic and continue to do business with Europe. So if standard contractual clause is the only mechanism that we can use at this time, then we have to go through that mechanism. And I'm sure Fred will agree, no lawyers are going to ever tell their client, no, you're okay, just well, we can wing it, right? No, we're gonna follow the law. And Schrems 2 overturned the Privacy Shield, or did away with the Privacy Shield, and so therefore we're stuck with the standard contractual process, the SCC. So we use those as a mechanism for data transfer. But I'll tell you, I've received a lot of Schrems 2 questionnaires recently, where we have to go through and I have to explain to my European counterparts what are all of the laws that could be the domestic laws that could be contrary to the GDPR. So, exactly what Fred was talking about, when you have a situation where the FBI could come in, what is the Privacy Act of 1974? Some of the attorneys I talked to weren't even born at that time. So they're like, what is this law? Right. So, we're dealing with that. And so, that's what we have, that's what we're left with, and that's what we're going to use.
Yeah, interesting. I'm going to come to the other panelists in a second. Just by the way, there's questions panel is still open if you want to ask your questions of our speakers. The LinkedIn profiles for them are in the chat, and also our teissTalk has picked a winner for the film title competition, which is Captain Adequate, the Adequate Avenger, which I think was absolutely brilliant. Bosco, I'm going to come to you in a second, but can I quickly go back to Fred on something that I've just thought about? Is the way open now for a potential Schrems 3 lawsuit where Max Schrems, who's the person behind all these lawsuits, sues the UK on the basis that our intelligence agency's surveillance of data makes us non-compatible with the EU? Is Schrems in for a sequel, a third round?
You bet. In fact, I think that lawsuit's already been filed, and if not, it certainly will be within the week. And I think we have to realize that what's happened in Europe now is a conundrum that largely reflects two different sources of authority. So on the one hand, you had the Commission and the regulators, and they've been working along, negotiating, trying to make things work under a fairly bureaucratic system. And then suddenly, kind of out of nowhere, came in this European Court of Justice that just started saying, boom, gone, that's out of here. So they threw out Safe Harbor, which was the first agreement. And then 3 years later, they threw out Privacy Shield, which was the next agreement. They've now notified half a dozen governments within Europe that their laws may not be appropriate. They don't provide sufficient protection, even though they are in the European Union club. And so there's a lot of confusion. And my heart goes out to people like Rebecca who have to advise clients, because you can say, well, the regulators say you can do this, but this crazy court out here may step in tomorrow and throw it all out again.
Yeah. Which is, that's a classic legal conundrum. You have laws made by statute and you have laws made by the courts. But in this case, the data industry moves so fast, it's hardly useful, is it? Robert Sparks has asked if there's any background on Schrems. The teissTalk might be able to help you, but have a Google if you haven't come across Max Schrems. Fascinating backstory. Got started by doing, I think Max Schrems got started by doing a data request to Facebook for his data, and got sent back sort of 2 reams of paper that he sort of brandished and said, look, this is how much they know about me. Facebook then tried to crack down on that and didn't want to do that anymore. And I think Max Schrems from then on hit the courts and has been there sort of ever since. Bosco, can I come to you now on this? Because as you say, you're dealing with sensitive data, health data of people participating in these trials and so on. Firstly, what are the extra onerous obligations on you, and how does that vary between different territory, EU, UK, US, further afield?
This industry is obviously very, very complex, but as well very heavily regulated. So you would expect that even before having GDPR, everything is already, in place. And obviously we have had clinical trials happening way before GDPR, and everything was functioning very well. But with the GDPR, it is just the matter of fact that now we have a hot topic or a burning issue, and I mean it is a good thing definitely, but as well not that good when we speak about making the whole situation very, very complex. So first of all, obviously you need to comply with various different regulations that you have in this field, such as good clinical practice and good pharmacovigilance practice. But then as well, you have a lot of various different separate regulations that are applicable to this industry. And on top of that, you also have a local legislation. And that's probably something that is making the most of our problems, not only outside of the European Union, as you would expect, because you think that yes, member states they're all the same, and the same rules are applicable over there. No, that's actually not the case. And even though the idea behind having the GDPR was to have a unified approach, it's actually not like that in the real life, because we have yes, the local laws are supposed to be in line with the GDPR, but in line with the principles of GDPR. But various different details are still open for the local legislation to address. And obviously, GDPR is not going into details, just setting up the foundation, and then it is up to interpretation of each member state to actually go further into details.
Yeah.
So a lot of different things that you need to comply with, and then now on top of that, you also have all these brand new privacy-related challenges that we are facing with.
Yeah. Just staying with you, Bosco, then, in terms of that, looking at the security, particularly the security side of this, how much variation do you find between member states in the EU who are all meant to be on the same page on this? How much do you have to work to get the data secure in each different territory so that it fits the rules?
Yeah, the most honest answer would be actually not that much, but that's not a good thing. The thing is that, unfortunately, with all these changes that we have and all these differences that we have in various different countries, it is kind of making the whole situation mission impossible for all of us to actually strictly comply with the specific local legislation and all the standards that you have in place and all the guidelines, etc., etc. And unfortunately, with all these kind of changes, and that's something that would apply as well for the part that you just mentioned, is that unfortunately that some of the aspects of privacy compliance are actually becoming a formality for a lot of different businesses, and they're actually not assessing each and every situation as they are supposed to, because it is just a lot of money, a lot of time, a lot of effort, and then when you draw the line again, a lot of money. So there is a risk, and you communicate the risk, but then for the business, again, unfortunately, it is far better option to actually proceed with just something that is very generic than to invest a lot of money into actually assessing and then customizing each and every aspect of the privacy compliance to the local requirements.
Yeah. And so, Rebecca, can I come to you on this? Because obviously you work, as you say, you work with in the cybersecurity field as well. In terms of the changes that we've talked about, the decisions around Privacy Shield, the EU decision regarding the UK, how does that affect then the sort of security industry and security of data?
So I think what Fred mentioned before, I think it's a lot easier to get companies to invest in their security as opposed to their privacy. I always say that they go hand in glove, which they do. You can't have privacy without security, but really, with the CEOs, the CISOs, the chief technology officers that I deal with at different organizations, that's the thing that keeps them up all night. It's not, are we doing things correct from a privacy perspective necessarily? And again, that's industry specific in the United States. Like healthcare industry, that's something that scares them because they're afraid of the Office of Civil Rights coming in but usually that's in conjunction with the data breach. So they figure if we fix the data breach problem, we're kind of like halfway there. If we can keep the bad actors out, we're never going to have to be subjected to an OCR audit. Unfortunately for them, OCR has somehow found new auditors, and they're starting to go out, but it's taken a really long time for them to get there. But most of the things that trigger a privacy breach in the United States is brought on from a security perspective. So companies are more likely to drill down on their security piece. And even there, we're seeing, I mean, Colonial Pipeline, JBS, SolarWinds, we're not doing it well. And I think that especially from a CISO perspective, and this is what I hear all the time, they're pulled in 50 different directions. Their goal is not necessarily aligned with, it's risk mitigation, but it's not always aligned with the legality of what they're obligated to do. If that makes sense.
Yeah. Interesting. Yeah. Actually, think about it. When you map out SolarWinds, Colonial Pipeline, and JBS, the meat distributors, I do think, first they went after the American government, and when that didn't work, they went after the oil and the burgers. And I don't know, maybe there's a strategy there. I don't know. Presuming the same group was behind all three.
They hit Americans where they live. Don't mess with their meat and don't mess with their ability to travel. I mean, that's what they want, right? So.
Yeah, indeed. Rebecca, just staying with you on that front then. So obviously, there's a lot of, as you say, there's a lot of things for CISOs to think about and to remember. When we get things like the adequacy decision, when we get things like the Privacy Shield decision and Schrems and so on, to what extent do you think CISOs are really sort of paying attention to that? Do they think, oh, well, it'll filter down to me eventually, or do they see the sort of security ramifications of those decisions as they come through?
I think they see them. I mean, CISOs, their biggest job is risk management and risk mitigation, and so they see that. The question is whether or not they have resources to devote to that. Because when you are looking at things like Colonial Pipeline and JBS, and you're saying, well, the biggest thing that seems to be looming is this security issue, I should be focusing more on shoring up my security, because if they don't get in, if the bad actors don't get in, I may not have this issue pop up in terms of regulators or concern. Now, in my opinion, it's a false judgment, and you actually have to be doing both of them at the same time. And if you do them well, you can blend them together in a way that works more with, my firm, all we do is talk about how we make things work with a business, right? These privacy laws, security laws have to work with the business. It can't constantly be the salmon swimming upstream. Unfortunately, in some instances, like the SECs, we are doing a bit of that, but we need to make it work organically with the organization and work with the business. So CISO, they are getting pulled in those different directions, and it is a real issue for them.
Yeah. Had an interesting question come through from Manny Vanan. Apologies if I got the pronunciation wrong. Quite difficult to tell sometimes with the text, but asks, how do privacy laws apply to data when it could be contextually transformed, like a screen grab, a JPEG of a database? And also, will a subset of a much bigger set of data be deemed outside any specific laws? So they've drawn the analogy with copyright laws. So you can use a segment of something under copyright law under sort of fair dealing and permit. Fred, how would you respond to that? What's the privacy for a screen grab of some data or a subset of some data?
It all will trigger privacy laws, and especially under the GDPR in Europe. I mean, the simple act of taking a business card from somebody, you've got their contact information, you put it in your briefcase, you get on an airplane, you've broken the law in Europe right there. It doesn't matter that it was one person's name and address. It doesn't make the least bit of difference. You've broken the law. Now, will they enforce it? Probably not. But on the other hand, if you had a business model that involves centralizing all that data in a server in Australia or the United States or China, then they might very well focus on that. And I think this was, part of the issue you were asking earlier about the interplay with privacy and security. Privacy, although we intuitively kind of know what it means, when regulators get involved, it becomes incredibly bureaucratic. It becomes, why do we see 1 million notices saying we're going to put cookies on your machine? Because a regulator required that. Does anyone know what that means? No, they just click on it. But regulators do this intricate dance. They can spend months on a single transaction. That's, of course, not how business works, and it's not how security works. And so what we often see is the kind of intricacy or bureaucracy of privacy actually getting in the way of security. So like good security might mean I put my critical data in the cloud where it's very secure, it's redundant, it's backed up, I can do everything there. But of course that breaks the law if that cloud is accessible outside of Europe, if you're in Europe. Or I can remember in meetings with the German Federal Data Protection Commissioner years ago, Microsoft was doing automatic updates, automatic security updates. And the commissioner said, no, you have to stop that. You have to mail out a disk to every person and have them insert the disk to upgrade their system. Well, we all know nobody will do that. I mean, 2%, maybe 3%, huge security blow, but it was thought to protect data protection rather than let Microsoft onto your machine. And so one thing we're seeing improvement in, I think there's reason to be optimistic, but that is that the kind of regulators who think about this from a data protection point of view, and remember in Europe, there are a lot more data protection regulators than there are security regulators, that they start getting some understanding about security and how their work might affect security as well, both cybersecurity and, of course, national security.
Yeah, interesting. Just thinking back to that business card example, I had a colleague who used he told me about this great service one day. He said, all these business cards I get given, I've never got time to sort of put them in my contacts book. So what I do is you can scan them and there's a character recognition service and then you can just download the contacts. And I realize now in hindsight that service was probably scraping every business card he put in and harvesting all of the people's data. But we only realized that afterwards. Bosco, can I come to you on this in terms of the conversation we had with Rebecca, just in terms of having a conversation about privacy being swimming upstream? I like that analogy. For you guys, to what extent do you think it's going in the same direction, the privacy and security conversation at EOMed?
No, not sure on this one, to be completely honest, because it is usually there is a tendency whenever we speak about the privacy compliance to just separate one topic and discuss about it like it's possible to discuss just as a separate topic. So for example, the topic would be international transfers, but it's actually just a huge amount of various different very complex topics and matters, etc., etc. And what I would usually see, I'm not speaking with within my company and business, but actually we have a various different stakeholders, various different clients, vendors, consultants, etc., etc. It is very interesting to see extremely different interpretation of the actual importance of privacy compliance, and then as well having both aspects, security and then as well privacy compliance working well together. So usually you never or rarely find something that is in between, in the middle, that is like, okay, we understand this is very important, but as well, the sustainability of our business and continuity of our business as well. So let's find a middle ground. Usually it is just we don't care about the privacy at all, or it is going into such details that actually it would make not possible for you to have your own business. And that's something that is very important, because Rebecca mentioned something, and I was thinking of the fact that usually right now we have the interpretation that actually privacy compliance, data protection, everything around information security that is important for the privacy compliance is actually preventing us to have our business, and it is just putting such a burden on our business. But that's not the goal of the privacy compliance. The actual goal of privacy compliance is to have better level of data protection, and actually to facilitate the rights and the freedoms of data subjects. And how you're able to do something like that is actually to have insanely robust global privacy compliance program, and then you can tackle with all the fine tuning, with the various different details, such as even collaboration between the information security and privacy professionals.
Yeah. Interesting stuff. Thanks for that, Bosco. Another question from Manny, which is an interesting one. Rebecca, can I ask this of you? The question is, does the US recognize terms like data processor and data controller, like in the GDPR functions?
So that's interesting. So when Fred mentioned this before, California has a privacy law, the California Consumer Privacy Act of 2018, the CCPA, And back in November, the good citizens of California also passed a new initiative, the California Privacy Rights Act, or the CPRA. The CCPA and the CPRA do not use terms like controller and processor. However, Virginia, the Commonwealth of Virginia, just recently passed a privacy law that does use terms like controller and privacy and processor. I am personally of the opinion, for what it's worth, that we need a basic glossary of terms that we're all going to use, and so we can stop this. Like, are you if you're a processor in one regard, or are you a business in an, no, let's just use the same terms. And so with my clients who are using different, I have clients who are GDPR, CCPA, CPRA, and now Virginia, because they're across the United States and in Europe. I'm like, we're going to pick a term, we're going to go with it, and we're going to follow GDPR because it's easier, and it seems to be the direction most other jurisdictions are going. I think Colorado, I don't know if I think they recently passed, or they're on the precipice of the governor signing a privacy law. I believe they're also following the processor controller. And so California is going to be the weird outlier. For those of us in the United States, we're used to that, right? We're like, oh, those Californians, right? I live on the East Coast. So we're used to that. But yeah, I think it's easier. Certainly HIPAA does not follow that. In HIPAA, it's a covered entity and a business associate. And so, we can use, but that's the key. And I talk about definition sections as being, people think I'm crazy when I say the definition section is one of the most important parts of the contract. Yes. And they're like, are you obsessed with dictionaries? No, I'm obsessed with using a term that everyone's going to understand. Once you define it, it makes it a lot easier. So with my clients, we tend to pick the terminology, define the terms to include other, so if it's a covered entity, we're going to call those the guys, the controllers and whatnot, and try to, as much as we can, cross map. But so that's a really long answer to the question that it depends in the United States.
No, it's a very good answer. And it's interesting because those, most of the time you can kind of draw an equivalence between the terminology, but the occasions when you can't is when the lawyers make their money and step in and go, oh, actually, I don't know whether we are a data controller. Perhaps we are. Yeah,
most important part is identifying your role in the data transaction. So, don't call yourself a processor if you're a controller. Don't call yourself a controller if you're a processor. Stop signing business associate agreements where you don't need them. I'm a big proponent of understanding the role you play, identifying it, and going with it.
Can I, sorry for interrupting. Can I just add very briefly to this one? And I hope that the listeners will find it very insightful, is that yes, everything is obviously correct that Rebecca stated, but you would even, expect that maybe in the US you would have, a different terminology used. So it's not a huge shock for all of us. But do you know that in the member states within the European Union, you would actually as well have a different terminology used. And for me, that's very ridiculous, because we are still struggling when we are speaking about the processing role allocation. We are a controller, you are a controller, we are processor or sub-processor, etc. And then, for example, you would have Italy. And then Italy would come with the local legislation, and they would say that we do not have joint controllers as, you would have if you apply the provisions of the GDPR. They have something that is called independent controller or autonomous controller. And then when you would ask them, what is this? Can you at least explain? Because, this is not going or fitting well into the clinical research environment. And we really do not have understanding of what is autonomous controller. And it is not defined in your law as well. And, how we are supposed to deal with this one. You're just like, well, we are autonomous controllers and that's it. So it is, it is a struggle even within the European Union, and then obviously we do not have high expectations for the rest of the world that we are going to have very unified terminology used.
Yeah, if we can't get it right within Europe, it's going to be a struggle elsewhere. That's great stuff. Really, really interesting discussion. I think we're slightly out of time, and as I say, I'm slightly worried that there's some kind of event on this afternoon that people are interested in watching. So I will bring it to a close there. I'll thank all of our panelists very much. Fred H. Kate, Distinguished Professor, and C. Ben Dutton, Professor of Law at Indiana University, Rebecca Ratkowski, Managing Partner at Expand Law Partners, and of course, Bosko Wojcic, Group Data Protection Officer and Head of Data Protection at Ergomed. Thank you all for watching. On Thursday, Jenny, my co-host, will be back standing in for me on Thursday. And it's going to be 4 p.m. in the afternoon. Time's changing on Thursday, don't forget. She's going to be discussing, this is a good one, this: does cyber insurance incentivize ransomware? And she's got Truls Erting, who is award-winning CSO, and Truls is an interesting chap to watch. So do tune in Thursday at 4. Best of luck this afternoon, whoever you're supporting. Anyway, congratulations on the mug, and I shall see you again next Thursday for teissTalk. Thanks to our panelists, thanks to all of our attendees. See you again real soon. Thank you.